Recording in progress.
All right, we'll call this meeting to order. This is the Holiday Island City Planning Commission meeting of December 14th, 2021. Let's start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Lynn, you want to call roll?
Commissioner Keys?
Here.
Commissioner Elwood? Here. Commissioner Graves?
Here.
Commissioner Mills?
Here.
Commissioner Dumas? Here. All present.
All right, I declare a quorum. I'm going to make one suggestion on the agenda, and that's to reverse the order of new business and old business so that we can address that resolution first and then go on to business. So is there any other discussion on the agenda?
I'll make a motion that we approve the agenda with the reversal. Second.
All right, we have a motion and a second. Any discussion? All in favor, say aye.
Aye.
Opposed? All right, the agenda is approved. Special meeting minutes from November 30th. I did not bring a copy of all the minutes.
They were about 5 pages long.
I will still entertain a motion to approve the minutes.
I just read them this morning. I did too, so I'll make a motion we approve them. I was not able, since I wasn't at the meeting, it was difficult. Second.
All right, Pat made the motion to approve the minutes, Jerry seconded it. Any discussion? All in favor say aye.
Aye.
Opposed? Minutes are approved. We don't have any reports, so we can move on to new business. Resolution HICPC R21-10, revising the use of digital broadcast application Zoom. I guess I need a motion to place this on the floor for consideration.
I'll move that we put HICPC R2110 on the floor for consideration.
Second?
Second.
Any discussion? All in favor say aye.
Aye.
Opposed? All right, Lynn, can you read the resolution? And just for the record, Lynn will read the resolution, but he will leave out the part that's basically just a cut and paste of the applicable Arkansas statute that we're referring to.
Resolution HICPC R21-10, a resolution revising the use of the digital broadcast application Zoom. Whereas the Holiday Island City Planning Commission HICPC conducts all of its meetings pursuant to Arkansas Statute ACA 2519-106, the open public meetings as presented here in part. Whereas Governor Asa Hutchinson issued a COVID emergency declaration, Executive Order 20-03 on March 11, 2020, and the Holiday Island City Planning Commission implemented ACA 2519-106, Section E1B, by conducting open public meetings through electronic means with the Zoom meeting video conference application. And whereas Governor Asa Hutchinson ended the statewide COVID-19 state of emergency for the first time on May 30th, 2021, allowing the statewide emergency to expire, Governor Hutchinson reinstated the statewide COVID-19 state of emergency on July 29, 21, following an increase in the Delta variant cases around the state. On September 27th, 2021, Governor Hutchinson allowed the statewide COVID-19 emergency to expire. And whereas the Zoom meeting video conference application and its competing internet-based applications are subject to technology limitations and difficulties, which make it impossible to achieve 100% reliability in ensuring the public's ability to attend and or participate in the Commission's meetings through this means, and whereas the Holiday Island City Planning Commission wishes to continue to conduct open public meetings pursuant to ACA 2519-106, Section D1C, through electronic means utilizing the Zoom session video broadcast application as a courtesy to the public under a modified process until such time as the governor issues another emergency declaration affecting public meetings. Now be it resolved by the Holiday Island City Planning Commission that the following Zoom session guidelines will be implemented. The Zoom session internet access link, meeting ID, passcode, and direct dial information will be included in official press releases to the media and interested parties. The Zoom session internet access link and passcode will be included on the agenda for each session. The Zoom sessions will be set up to require attendees to use the passcode to get access to the meeting queue, eliminating the requirement for the on-site host to admit attendees electronically. The Zoom session host will start the session shortly before the appointed time, automatically admitting all attendees waiting in the queue at that time, and then start the recording of the session just prior to the start of the meeting. Zoom participants will be able to automatically be admitted throughout the meeting by using the required passcode after the HICPC chairman calls the meeting to order. The Zoom session will be... Whoa. Gotta mute a mic. The Zoom session will be used in a broadcast-only mode. All Zoom participant microphones shall remain muted for the session. The HICPC chairman will not solicit comments from Zoom participants, and the Zoom session host will not monitor the session for participant raised hands or chat. The Zoom session host will end the recording of the session at the meeting ending gavel, and the Zoom session host will post the recording of the session in the customary way in a timely manner. Passed and approved by the Holiday Island City Planning Commission, Holiday Island, Arkansas, on this 14th day of December 2021.
Okay, is there any discussion on the resolution?
One question on the fourth, whereas on the second page.
Yes, sir.
It says, and continue to open pursuant to, and then it said through electronic means. We're not going to use electronic means.
We're going to use the electronic means of the Zoom session video broadcast.
Video broadcast. Read the whole.
We're going to use Zoom in the broadcast mode, not in the meeting conference
Through
mode.
electronic means, yeah, but that, when it says that, I don't know, I stumbled on it. I don't know, it just didn't read right to me. I said, you say, however, electronic means you will be, I don't know.
That's what a Zoom
Using the
is.
Zoom session video broadcast.
Yeah, I mean, it's the same as we've been doing, except there's not gonna be,
Just a one-way.
it'll be a one-way broadcast.
Okay, if everybody else is.
It could, I suppose you could reword it,
To me,
slightly.
it says we're conducting open public pursuit through electronic means, which takes it back to, you know.
I understand your point.
Okay.
I do, I understand your point. And if you took out the through electronic means and
Or just say however
and-
electronic
and
means.
said, and
Yes.
will utilize the Zoom session video broadcast application
Oh, okay.
as a courtesy.
I think it's just change the word through to and.
Well, you can't just say and electronic means.
And through electronic, you use the Zoom.
Well, why don't you just put broadcast between there? Public meetings and broadcast and take out the through. Does that make any sense?
You can use open public meetings pursuant to that section
And electronic,
And
offer-
broadcast using.
and electronic means used
and
as a courtesy.
and use the Zoom session video broadcast application as a courtesy.
Yeah. That. Or you could take that out as a, and as.
What about including?
But anyway, let's see.
Word it however.
And through electric.
Any of those changes will work.
Will be used, okay, I got it. And through electric use, as used as a courtesy to the public. Okay. Right, and
I don't see an issue with it.
that don't read right. The through, to me, when I read it, read back the through, you're gonna do the public meeting
We're gonna have a
through.
public meeting, and as a backup, we're gonna do it electronically through the Zoom app. I mean, that's
Okay.
it.
Or you could say, and additionally, through electronic meeting, and additionally.
Well, the statute in 1 says, all officially scheduled, special, and open public meetings shall be recorded in a manner that allows for the capture of sound, including without limitation, and C, a digital or analog broadcast capable of being recorded. So we're doing it through the statute by doing C, a digital or analog broadcast capable of being recorded. That's how we're doing it. We're doing it.
Okay. All right, nobody gonna read it that close anyway.
So what did we settle on, leaving it at?
Leaving it like it is.
Okay.
Works for me.
Any other discussion? Not, I'll entertain a motion to adopt resolution HICPC R21-010.
I'll move we adopt it.
Linda made the motion, do I have a second?
That's second.
Ken seconded it. Any further discussion? All in favor, say aye.
Aye.
Opposed? Or do we think we needed a roll call vote?
We've done roll call votes on all resolutions in the past, so.
Okay.
Commissioner
And,
Keys,
Yes.
Commissioner Owen,
Yes.
Commissioner Graves,
Yes.
Commissioner Mills,
Aye.
Commissioner Dumas, aye.
Hey,
Oh,
you forgot Pittman again.
Oh, Mr. Pittman,
I'm technically not at the meeting.
you're not even at the meeting, I didn't have you on the list. I'm sorry, I missed Mr. Pittman in the agenda, in the
Roll call.
attendance.
For the record, I'm here and I vote yes.
Oh, my apologies.
My bad.
All right, the resolution is adopted, and in the process of doing all the discussion, I wrote all over my copy, so we'll have
I have
another
one copy.
to sign.
All right.
All right, moving on then to old business, action items from November 30th discussion. And then it's your show from here on out.
Okay. The action items, I didn't have a long list from the minutes. In fact, I went back through and there's only a couple things that I think we're going to address anyhow in today's meeting. So we pick up with our discussion on these regulations that we haven't explored yet in dot 240. And the notes that I have, it's at the top of page 55. The section is called compliance.
Page 55?
Yeah, it might be 54 in your notes because I.
Yeah, I didn't put a clip on it, so.
Okay. So the compliance simply says that constructing and locating and altering and changing the use of any structures requires full compliance with the provisions of this subchapter. So it just lays out the law that says this is the law. Any comments?
Nope.
241 is fees. It's a simple sentence. The applicant shall pay the fee listed on the permit application as adopted from time to time by a city or council. So the adopted from time to time gives us that allowance to change that fee schedule as needed.
So that suggests we're gonna have to change the form every time we change the fee.
Sure.
It's not that hard.
Okay. Permits is 242. Talks about the applicability of all the things that are covered, and it mentions at the end must be approved by the current floodplain development permit application. So I don't know about, we've decided to leave the floodplain text for later. Should I leave it in here for now and it'll just be in the reserve section that we don't really have addressed? Is that okay to do it that way?
You could say if one exists.
Yeah.
Well, it'll be the current floodplain, so right now there is none, there will be one in the future possibly.
Okay.
Okay, all right. There are no exceptions in B, may be granted without a written request, again, the floodplain administrator. So this kind of applies to floodplain. And it's just the tail end of all that floodplain stuff that we just skimmed through and passed over last time we met.
Are these permits only pertaining to floodplain?
That was the question I
Kinda
had,
weird.
and we have a fee section at the very end of this document. I think it's like 390 or something. The very last section talks about fees, and it's got a little bit more language in it. Because of the numbering scheme.
Okay, go back and look at 14.234, lands to which this subchapter applies.
Okay,
It shall apply to all special flood hazard areas within the jurisdiction of the city.
because I think the way it was numbered, the 200s are all the flood stuff. 230 through 2399 are probably all flood stuff.
If we don't have any floodplains in all
I don't
that,
think we
let's
have
just
any.
leave it out for now.
Okay,
Just, you know, we can
Yeah, actually, it
indicate
sounds like
reserved and that,
all these
someday it could-
paragraphs down through here should be reserved.
yeah.
okay. I'll make that note.
You know, start with 234.
Through the
Through-
242.
Yeah, 242.
We need to keep the, you know, the first shot at the, at this zoning ordinance as free of clutter as possible, because some poor code enforcement officer and building inspector is gonna have to, be familiar with this so that they know what to approve and what not to approve, and it, you know,
Well, I don't think,
it could get confusing.
we don't have any, but
We know that for certain.
Well, we talked about last meeting and talked about parts of Haddock Creek is under control of the Corps, so it must flood. And it covers roads.
If they raise the lake level, it can certainly
Well,
flood.
it doesn't FEMA or some agency federally maintain a floodplain?
Yes. The
That's-
county would
have a flood.
have a floodplain map.
That was the one action item that I was supposed to work on, but the last thing we decided was to reserve it, so I didn't work on it.
Yeah,
I think we're,
I still think.
I don't know,
that's
we've
fine.
been here and the lake's got up to 437 or something like that. I mean, 937, and it ain't flooded anything.
Okay, so,
we could look at a topographical map of Holiday Island, and if at any point in Holiday Island it's lower than the top of the dam at Table Rock Dam, then it could flood
You're in
here.
trouble.
Otherwise, not too likely.
okay. Then this whole section starting with 260 is the Board of Adjustment.
All good.
I made a note that statute uses Board of Adjustment. I found that in a couple places, but more often it's used the Board of Zoning Adjustment is what the statute's title is, board. Yeah,
What did we call it in the building code?
I don't remember.
I'll look at that.
Okay.
Look at it real quick.
The requirement of the statute is that after we get the land use plan done and then we work on the zoning map, we have to have the map, the text, and that same statute says, and we also have to have a board of adjustment created. So that's why it's a part of this group. If it's zoning regulations and board of adjustment come into the same statute is why they're grouped together. So for the building code element that we passed in the city council, we may be a little bit lacking in not having a board of adjustment because it does talk about zoning for a bit in our current one. So we've got to get this part done as part of our initial release.
The little process diagram in the building code refers to just a board of adjustment, and the first paragraph calls it board of adjustment.
Okay. So should we use board of adjustment throughout the text rather than board of zoning? If we do, that's fine. I just have to know what to do.
Well, this will be the board that any variance in the code
Mhm.
will go before.
Mhm.
And yeah, I think board of adjustment would be all inclusive. zoning.
Sounds more inclusive.
Yes.
Okay, I'll take that and make that note. So, it says the Board of Adjustment is hereby established and shall be composed of the City Planning Commission as a whole. Is that our intention? So all of us in the City Planning Commission will also be the Board of Adjustment.
I would change the acronym in parentheses to
Sure.
BOA.
Yeah. The BOA.
To BOA. The boa constrictor.
Yeah, all appropriate.
Well, it's better than
Or-
yes.
Or can I refer to the document as the Board of Adjustment, but call it the Holiday Island Board of Adjustment? So it's a highball,
I go,
alright.
Okay.
Can I just
So what should we call it officially? Holiday Island Board of Adjustments, there's no confusion?
Yeah, that's fine.
Okay.
But let me just address what you just said about the planning commission sitting as the board of adjustment.
Yes, sir.
I mean, that's the appeal going to the people that just rejected it.
Right, except it'll be in a different forum, you know, it might be additional information brought, a better argument brought, more defense, because that's the requirement of the people bringing a plea to the Board of Adjustment, have more evidence, I guess. The statute allows that to happen, and the minimum says it has to be 3 people. But it does say that the planning commission can serve on the Board of Zoning. The statute allows it.
if you appointed 3 different people, if the mayor appointed 3 different people to this board, they would have to be intimately familiar with everything in this, I would think. Which
Just as a
might
judge would.
have trouble finding
That's it.
anybody who wants to do it.
At some point in the future, you know,
I mean, I could
it
see
may
both
take,
sides.
it may take a couple of years, but at some point in the future, you know, this group of people here won't be,
Well, no, but any group of people, I just see some issues arising that you're appealing to the same people that just rejected you.
I think that's a valid point.
And then the same thing happens if that Board of Adjustment agreement or doesn't go well with the petitioner, then he petitions to the city council. Again, it's the same group.
Yeah.
Well, initially it is, but Dan says down the road it's not going to be.
Right, right.
Well, we can hope that eventually we get some other folks interested in this subject matter area.
does it, we don't limit how many members, or we don't state in here how many members are gonna be on the board.
No, 1456-416 says members or the commission as a whole may sit on the Board of Zoning Adjustment. So reading that, it doesn't say a part of, it just says
What's that section code?
1456-416, 56-416.
Is that in here anywhere?
I don't, no, it's not in this document.
Okay.
It might be in that,
That's a
that
good
tablet that I
reference to
gave you.
have.
I left that one, here it is. I don't think it's in this.
In that other document, okay.
414, yeah, 416's here. By the way, it was changed in the section of 2021, but that section did not change about who can serve.
So what is, read that section of code?
Is Rule 3 and we're into sentence 4. The ordinance shall provide for a Board of Zoning Adjustment, which may either be composed of at least 3 members, or the commission as a whole may sit on this Board of Zoning Adjustment. So it could be 3 members or the whole planning commission is the option.
But either way, they're gonna be from the board, from the planning commission.
Yeah, but if it's only 3, that makes it a little bit different than the entire board.
I'm thinking that 3 don't have to be commissioners. I'm guessing they have to be,
Could be
but
any.
other than commissioners.
Maybe 3 people, perhaps.
Well, maybe they could be the commissioners. It doesn't say they can't be.
No, well.
Which may either be composed of at least 3 members, or the commission as a whole may sit as the board.
I don't know that it's gonna become an issue here, but to Jerry's point, you know, if I were a property owner, and I'd be looking to do something, and the planning commission turned me down, and I'd say, well, I wanna appeal to the zoning board. Okay, we'll recess and we'll come back in
Yeah.
5 minutes as
I think the options
zoning,
are
We
bad.
can't
as
do
the
that.
adjustment board, and then, well, I wanna appeal to the city council, well, let's adjourn for 5 minutes and we'll come back as the city council.
I think that ultimately it needs to be a
Yeah,
I mean, it needs to be the planning commission, 3 people or whatever, how many ever board of adjustment. And then, you know, you got all these different steps with different people.
Okay,
as long as, if our zoning ordinance gives the mayor the authority to appoint a 3-member, board of adjustment, subject to approval of the city council. I think that's the way I would like to see it and the way we would wanna do it eventually, maybe even sooner rather than later, just because of that
So
fairness
you could
issue.
start with 3 members from the commission and then, switch them out as time goes on.
Yeah, just find 3 independent
What about that statement down there, a quorum of the board shall consist of 3 members?
well then if you only have 3, it has to be 100%.
Yeah, you gotta,
Can't meet unless all 3 are there.
True.
Because it also says, you know, it's a majority of the whole board, so on a 5-member board, it'd always be a 3 vote.
But that statute says it's either 3 or the planning commission.
anyway,
It can't be more than 3 or the minimum of 3.
No, I think it's at a minimum.
Minimum, okay.
it says a quorum of the board shall consist of 3 members, so I don't.
The ordinance shall provide for a board of zoning adjustment, which may either be composed of at least 3 members or the commission as a whole.
Why don't we just say it will be people appointed by name? And that will be that can be a long-term.
I think that's in here someplace, I read.
No, we're talking about the language of 260. Shall be composed of,
5 members.
Well,
Like
5 members appointed by
I'd
the
say
mayor.
3 to 5 appointed.
Yeah,
No, you gotta have 5, if you're gonna have a quorum, it takes 3 for a quorum.
we're trying to draft the language to give the mayor flexibility.
shall be composed of 3 to 5 members appointed by the mayor and approved by the city council. And as soon as we adjourn here, I'll appoint you guys.
Well, you won't do it then, you'll appoint us in a meeting, the city council
Of
meeting.
course, you could always refuse to approve yourself.
If he calls my name.
Yeah, you got all.
Sorry, Jerry.
Yeah. You've been deposed.
I need another history lesson.
I think that sounds good.
Alright, so I changed it, say, which shall be composed of 3-5 members, comma, appointed by the mayor and approved by the city council.
Well, then,
Okay,
what are you gonna do with that next sentence down there then?
make a suggestion.
Well, if you leave the board or the commission or whatever, board at 5, then a quorum is 3, but if you only got 3, a quorum is 2.
That's what we just wrote. It could be 3 or
I'm
5.
gonna take this call, and you can keep going with the meeting.
Well, we can leave the language to just declare it, the quorum is 3, not 2, it is 3.
Okay. Well, everybody, all 3, you gotta be there.
Yeah.
Yeah, I don't see a
Yeah.
problem with that.
Okay, I just brung it
They
up.
won't have a meeting if they don't
Yeah,
have 3.
can't have a meeting.
Okay, go.
Okay,
So
so,
5 people is gonna be.
I have highlighted here as well as several other places, the administrative officer. We need to be clear what the officer or the official is. There is some explanation of that down in 280, if you wanna skip there real quick.
Yeah, I read it later on.
Yeah.
Pages 2.
In 280 on my notes is page 58,
58, yeah.
but my notes are changing, so.
Did they define administrative?
Yeah,
officer?
yep, quite a bit.
but shall be administered, under the direction of the building zoning official, administrator.
Again, it talks about the building department, which we don't plan to have. It calls it a building zoning official, at the direction of that person, which we don't have.
What did we?
Could make it the mayor.
The person.
Well, that's why I'm wondering what we're gonna do with this language, because this administrative official or officer appears in multiple places.
Did we have to, did we?
I don't think we want to
The
do
stuff
mayor.
we've done, we start talk about a building inspector or something.
Yeah.
Well, you could, I mean, like in this sentence, it might be the decision of the building inspector.
Mhm.
Issuing the permits. That's
Yeah, whoever's
issuing
those
the permits.
permits would be the administrative officer.
It's kind of what I thought.
Yeah,
Yeah. I don't know what term we use for that.
I would say building inspector at
Okay.
this point.
Okay.
I mean, that's who, well, the building inspector has to look at the application for a permit and see that it adheres to all
Yeah.
these.
And they're gonna be making some independent decisions occasionally. Cause he, in that process, he has a choice whether to say, okay, I think this will be okay, or pass it on to the Board of Adjustment.
Okay, so if we, wherever we see that,
Administrative
that
official.
official or whatever,
Be a
let's
building-
think on building inspector, and I'll change the text later rather than hunt it all down.
Okay.
So Dan, for your benefit, in 261, we've talked about the administrative officer, the administrative official. We looked at the definition a little bit down in 280, and we're going to use building inspector every place we see that official or officer name.
Okay.
All right. Powers and duties then. So this is a section that defines what this Board of Zoning Adjustment has the right to do or the requirement to do. And I highlighted the title. I underscored in B. To authorize upon appeal in specific areas such variance for the terms of this zoning chapter as will not be contrary to the public interest where, owing to special conditions, a literal enforcement of the provisions of these regulations would result in unnecessary hardship that would deprive the owner of any reasonable use of the land or building involved. A variance from the terms of these zoning regulations shall not be granted by the Board of Zoning Adjustment unless and until then all the conditions are listed below. So this makes it clear that the Board of Zoning Adjustment doesn't have free will to do whatever it wants. It has to administer these regulations that we've created, imposed, or approved. So with that, in section 1, the third sentence, it says structures or buildings in the same district, semicolon, you need to put the word "and," that literal interpretation.
Section.
I'm in 262,
Powers and
paragraph B,
B, okay.
and then 1, third line.
Got
We need to put an "and" in front of that literal interpretation. And 2 lines down, we need to insert an "and" in front of that special conditions. Because there's other "ands" in here, they just didn't put them in that one. I think they need to be inclusive. That it shall not be granted unless and until all these "ands" are met. That's my recommendation.
Yeah, on one hand, you would like to have a little flexibility, but with flexibility comes judgment and
Favoritism.
favoritism. And you, like it states in here, you can't grant a variance to one person for something and then turn around and refuse the same variance to other people. Or maybe in the past you've refused it to other people, but in this particular case you want to make an exception. So,
So where is the "and" going?
In the third line, structures and buildings, structures or buildings, right at the end of that, and that literal interpretation.
So take out the colon,
No, leave it there.
semicolon altogether?
There's several ands in there already, so I just inserted and.
But it sounded like this was a list of all the things that had to be met, because
Yep.
the last one had the and. I mean,
Oh, I understand. Oh, the English language problem that I have.
right.
Oh, okay. Well, there's an and up here.
Where?
Building and which are not applicable to the, no, that's part of the sentence. I think you're right. It doesn't need to insert. Linda pointed out that the and is at the last condition, so it's because it's a list.
It's a complicated string of things with an and at the end.
Yep, so I'll take mine
I'm
out.
having a flashback to my high school
Yeah,
English teacher.
Linda's correct. We don't need ands. Okay,
If you want all those things to be inclusive,
they are.
okay.
Yes.
Okay, so skipping down through these, I didn't find any issue. I just made a note in 6 to myself that under no circumstances shall they grant a variance and allow use that's not permissible. And then finally, or it's prohibited by the terms. So that reminded me that in the things that we have up above that we talked about months ago, we need to have a list of stuff that is prohibited and mark it as prohibited. So that paragraph 6 has force.
So right now, there's nothing, that we didn't prohibit anything?
Well, when we talked about
Specific.
adult entertainment, that might be a box we put and mark not permitted. So it's clear from 6 that it's not permitted, and that's why. That gives the enforcement of 6.
Okay.
So whatever uses that we don't want permitted, we need to tabulate those as best we can.
Or llama farms, or,
Well, we said no farm animals.
yeah, okay, so
We
that's
said
not
last
being
time.
prohibited. So that's
Right.
not being prohibited.
That'd be a prohibited thing we've talked about. So having this 6 gives that force. Okay.
I guess I'm trying to think of ways that, you know, the real situations that are gonna come up here, where people are gonna be asking for variances. One of the most typical ones is going to be the easements, where, you know, there's 15 feet side easements on the sides of structures, but it's 15 feet total. The house doesn't have to be centered, but it's got to be at least 5 feet. 5 feet is the minimum that you can have a structure from
Is that
the
a
lot.
setback or is that an easement?
Setback.
Easement is
Yeah.
right of way, isn't it?
Yeah.
Easement is the distance from you and the next line.
Setback, okay.
Backyards, most of them are 25 feet. If somebody wants to extend their patio, and in order to do it, they have to be 6 inches into that 25-foot setback. Are we going to be able to grant that variance if it doesn't do any harm? There's no real reason in the world not to let that person,
To me,
Well,
that's a
6
true
inches.
variance.
huh?
To me, that's a true variance.
Yeah, but are we saying in here that we can't grant that variance because it says?
Because the law says 25 feet.
Yeah, because, you know, we said you can't, it
Did we
says,
say
you know,
anywhere that that's absolutely prohibited?
Yes, because we're gonna have a column that says setback from rear line of property 25 feet. It's gonna be in the
You can't
statute.
have any structure, any development within that setback space,
Right.
is what you're saying. That has to be clear space. No fence, nothing.
No, fences are permitted differently. Fences could be closer than that, I
So
think.
you could dig a flower bed back there.
Probably, because it's not permanent, it's not hard structure. So we have to define that, don't we?
Possibly.
What
Maybe
kind
that
of-
makes the
From
difference.
my past experience, if you don't have a little leeway, all hell will break loose. I mean, we had an issue on the council I was on where, the head of the, called Community Development, Department, but he was the building inspector, and we had a workshop where he came and explained that if he had the power to recommend to the planning commission and ultimately to, up the chain, to grant slight variances, and give him that discretion, that it would be a good thing, and it was.
Maybe the answer that we have is in language in 3. The last part of it says that the variance is the minimum variance that will make possible the reasonable use of land, building, or structure. So it might be reasonable to let that patio be 6 inches past the 25 feet.
Yeah.
That language is there in 3.
If that gives the person making, or the board making the call, a little bit of latitude, then I'm okay with it, because just in my short involvement in all of this, within the last, 6 months or so, it's come up several times, because the lots in Holiday Island, by and large, are very narrow. So if somebody wants to do anything whatsoever on the side of their house, they're gonna be a foot or so into that setback. And
Well, and don't you think it also, you would wanna know, it should come before the board or something, because they need a good reason if they're gonna go over that setback. And so, 6 inches, why couldn't it be brought back 6 inches? What difference is that gonna make to them? But if they had a good reason for it, I
can
should
see.
listen.
Yeah, I can see some of the terrain here that, if I can get 7 inches, I don't have to dig through, 6
Yeah.
inches of rock.
Yeah.
And,
The terrain it sounds like a reasonable excuse to me.
now it does make it judgmental.
It
If
does.
somebody comes and says, I wanna build something, on the side of my house, I wanna build a little, and I wanna turn my 2-car garage into a 3-car garage, and in order to do that, I gotta be, a foot from the lot line. We're probably gonna say no. If somebody comes and says, I wanna add a 3rd stall to my garage, and I need to be a foot into the setback, we're probably gonna say yes. So where does yes become no?
You'll just have to, whoever's making these decisions have to note what the discrepancies
and
are.
there'll be a learning curve, because there'll be a time where, that the building inspector will recommend something that we don't accept, but that sets a
It
precedent.
does.
So the process is, I want to do something, and I ask the building inspector, can I do this? He says no. So then that person says, okay, we're going to follow your procedure. Then you have the hearing, and that's when your neighbors are notified and the whole 9 yards, so people can come and talk about this request to violate the standard. And then it gets heard, both sides, and then you make a decision, does it grant it or not.
I think that's probably the deciding factor. If the decision is made in a public hearing, and the neighbors have no objection,
And it's only a foot, you're not violating the whole setback.
Because the building inspector has to say no, because it's phone. Now you have to take it to a higher level.
Yeah.
So if we make it clear the building inspector follows the regs to the letter, anything variance has to be asked of the Board of Adjustment.
Right.
And it becomes a public hearing, and everybody influenced by that request has a chance to say
I think
something.
that's a
That
reasonable
sounds good.
approach.
That'll work.
So, we're taking out this statement in 6, or it says under no circumstance?
So how would that be?
No, we're gonna, well, okay.
Well, I thought that's what
Grant
it
the variance
says.
to allow the terms, or any use expressly.
Grant a variance to allow use not
The board of
permissible.
zoning adjustment should have discretion.
I think we can leave it here because it says twice, in these zoning regulations. And 3 gives them reasonable, it gives them a chance to use their reason. Now, they're conflicting in that regard, I guess.
It says under no circumstance.
Yeah.
Yeah.
Take out 6. Take
And
out,
that's the sentence that I had, issue with, the under no circumstances.
I think
part
if you
of
take
it.
out if you take out 6, then you can go forward. I mean, that's the purpose of the zoning adjustment, is to make exceptions. Or grant variance, so.
I guess maybe this is to protect the integrity of the rules that were written
I know, but.
and not let just some wild
I
card
know, but that's.
people on the board of
That's what
zoning
the
adjustment.
duties, that's what the zone, board of adjustments for,
It is.
to see if you can.
Well, let's back up. This is talking about the use is not permitted. Is putting a concrete pad
Oh, a
6
use.
inches over a line a use?
No,
I'm
I
lost
don't
again.
think that's a use.
We're talking about use, like I want to use it for a gambling casino, or I want to use it for a restaurant, versus I want to put a patio 6 inches over a line. Is putting a patio 6 inches over a line a use? It's using the land.
I don't know, I don't know why the board of adjustment.
I kinda agree with Ken, that number 6, just, I mean, it contradicts everything before it. We talk about, in granting any variance, the Board of Zoning Adjustments, that's in number 5, and then number 6, under no circumstance shall they grant a variance to allow the use not permissible. I mean, that,
I don't know.
I think it's the definition of use that they're covering in 6, not any kinds of variances.
Well, what's the use?
If you're putting something on land, you're using it. I mean,
yeah,
if you're not permitted to build within 25 feet, and you put a patio within 25 feet, that's a use within the 25 feet. I think we just need to take 6 out.
The definition of use is any functional, social, or technological activity which is imposed or applied to land or structures on the land.
Yeah.
So 6 is talking about use.
Like
Okay.
gambling, or
Anything. I mean,
Airbnb.
I want to put a restaurant in the middle of that residential area. That's a use.
okay, so
Where's it?
going 6 inches over the line.
It's not use. Because use is defined as a functional, social, or technological activity.
It's an activity that you're gonna do on that piece of land.
Okay, so the key word is use.
I think so.
Okay,
So it's saying that's why I said originally, our table that says what's permitted and not, we need to be clear about what's not permitted, because 6 gives it the force.
And if someone makes a good case, then maybe you go back and add or change the uses
We gotta change the reg.
in the regs.
So they could
That
say,
would be the
that's the only
remedy.
solution,
That
right?
would be the remedy.
okay,
Okay,
moving right along.
okay,
I gotta find my note again.
okay.
What age?
I think we're on
56.
56, okay.
Now we know why.
So
it's
6 is okay.
Now we know why we had the
Okay.
lawyer look at it.
Use is the key word.
So again, at the bottom of that page 56, in C1, it's okay to say upon appeal of the building inspector's determination, that's still okay?
Yeah.
Okay.
C1?
It says zoning official. I just wanna make sure building inspector works every place.
Yep.
Okay. All right, next page. I have a problem with 4 concerns that a permit in addition to a non-conforming structure, provided that said addition conforms to all the building code requirements, and further provided the current use of the structure conforms to the zoning district in which it's located. We spent a lot of time talking about whether you can add on to a building or not. And it's in .043, repairs and alterations.
No, we were talking, yeah, we were talking about that.
We said in that section that normal maintenance of a non-conforming structure can occur. We crossed off the 25% gross floor area. And it says alterations may be made, but it says in C, no structure partially occupied by a non-conforming use shall be altered in any such way as to permit the enlargement or expansion of the space occupied by such non-conforming use. So we set up in 43, you can't make it bigger. 14, or this 4 here, says permit an addition to non-conforming structure. I don't think we want to permit it.
I agree.
Because the title of C says the Board of Zoning shall have the following powers and duties to hold the hearings and decide these exceptions. I don't think we should allow 4 as an exception. We already said no in dot 43. Yeah. In section 443C, it'll be renumbered. I agree, I don't think we should have it, that's why I struck it. Finding it. It's on page 16, sorry. In 43, last sentence C.
No structure partially
Jumping
occupied
around too quick.
by
I ain't
non-conforming.
figured out where the hell we're at.
That's a fault. Way too fast.
I thought we went from 62 to 63 and that thing.
We're not to 263 yet.
Okay, we went back to where?
Number 4 on page 56.
Okay,
We struck number 4. In
permitted addition to a non, it said that, you know,
I'm okay with striking it.
permitted addition to a non-conforming structure. I think that's the key there, is a non-conforming structure, right?
Right, the question is, are we going to permit the Board of Zoning Adjustment to allow that? We said in 43, it's not going to be allowed.
Well, you've already got something that wasn't right to start with, and
Right.
you wanna make it bigger?
Right,
That's exactly it.
That's kinda dumb.
okay.
That's right.
It's struck.
Brian wants to strike it.
Yeah.
Okay.
Well, I'm just agreeing with it.
Okay, good. All right, in the next section, in that first 263A, Andy
Wait, before you go on.
Yeah.
I took the pulse of this, of the horse that we were beating a minute ago.
Yeah.
And there's still a little pulse there.
Okay,
So I want one more whack at this almost dead horse.
Whack.
In 14,262.
okay.
I still think we should strike, number 6. Because that whole section, 14,262, talks about uses. Uses of the property. It says that basically it says that the board can issue variances under condition 1, under condition 2, under condition 3, under condition 4, under condition 5, and then it gets to condition 6 and it says under no circumstances. It's all talking about the same thing.
You're right.
Does it use the word use?
Yeah, it does in B,
Yeah.
reasonable use.
Okay.
I missed that entirely, I'm sorry.
That sentence 6 just does not belong in there.
Okay.
It doesn't belong because of what we've already talked about approving.
Yeah,
Okay.
it just doesn't make sense to leave it in there.
What? You says you can't, a variance to allow a use. Well, are you making a variance to the use, or are you making a variance on something else?
That whole section 14,262 talks about the use of the property. And it says that, in so many words, it says that the Board of Adjustment can issue variances under certain circumstances until you get to paragraph 6, and then it says under no circumstance. So, it doesn't make sense. Just take it out.
Well, all the other ones are talking about variance and And that one gets down and is talking about use, I don't see use.
It's all about use, that whole section is. It starts out in B, talking about use. Font. I agree, Dan. It's contrary
I
to.
thought that's where we were 6 hours ago.
It was.
That's why he's talking about being a horse that has a heartbeat.
No, yeah, the horse wasn't quite dead enough, so
We'll call it that, let's.
yeah, move on.
6, I struck 6 then.
Okay.
Alright, in 263, second line, any decision of the building inspector. So appeals to the Board of Adjustment may be taken to any person aggrieved, maybe by any, okay, or official department, or any decision of the building inspector. That fits. Good. Okay, in B, public hearing and notice. Here we are running into that language again, that it must be published once, not less than 7 days preceding the date of such hearing in a newspaper of general circulation. That's the force that I've been chasing.
Yeah.
And 1455-206, it's entitled, it's for local government, municipal government, ordinances of municipalities, and procedures for adoption. It's subtitled Publishing or Posting Requirements. A, all bylaws or ordinances of a general or permanent nature, and all those imposing any fine, penalty, or forfeiture shall be published in a newspaper published in the municipality. Then it says B, in municipalities in which no newspaper is published, written, or printed, notice posted in 5 of the most public places designated by the body, and it goes on. So I think we're okay with ignoring or not using the language that's in here that it needs to be published in a paper because of what 1455-206 instructs us. And since, this subject's come up, I've paid particular attention to the few newspapers that I get locally, and there's nothing in there from Berryville, Eureka Springs, Green Forest, about any of this kind of activity we've been talking about needing published. Sure.
See, I would argue that where is the Carroll County News? That's headquartered in Berryville, isn't it?
It's published in, I don't remember what town, but it's,
Published in Berryville.
I would think they would need to, but.
the court does, the quorum court does, and yeah.
But what you just read, I mean, we don't have a newspaper published.
No, we don't. And that's why we did the boards for our ordinances, and this will be an ordinance when we're done. We're making this into an ordinance and turning it into code.
This only pertains to ordinances, doesn't it? I mean, it looks like it does. Am I reading that wrong?
Bylaws or ordinance of general nature that impose a fine fee, a fine, penalty, or forfeiture. This is going to be an ordinance. We're going to pass this. This language is going to be in an ordinance. Adopt this code.
I know it will, but what I'm reading is B title says public hearing in notice.
Okay.
And it says, we'll fix the time, give public notice of the time and place, as well as notice to the parties of interest, and decided, said public notice shall be published at least once, but not less than 7 days preceding to the date of the hearing. They're talking about publishing the notice in this paragraph, not the ordinance.
Okay. You're
So
right.
I don't think it's a necessity at all. Yeah, we gotta publish notices, but we have a recognized alternative by putting them on our boards. So I don't think we're under any obligation to publish in a paper notices of hearings. We'll use whatever means will reach the people out here as best we can.
Get a town crier.
That'll work.
We do, we've got a HICPC newsletter, which
We
is
got the
published.
newsletter, social media, that's
And
the
five-
only thing we got out here.
Yeah,
I think
It's not a
we're okay,
requirement,
we're okay doing what, posting in our
Yeah.
5 bulletin boards.
yeah.
I'm pretty sure of that.
Okay. So I'm going to go through this and look for, I'm going to strike all language requiring publication.
look, and
Do I need to substitute with language that we're going to do our customary notification
Yeah,
process?
I would put that
And that's almost the language.
all variances, et cetera, will be posted on, 5 locations in the city and, included in a generally distributed, newsletter that goes to all residents. You may not want to need to mention that, but I think we need to just spell out that we'll do the posting on the 5 boards, various locations.
Okay, obviously this language, we're gonna go all through this again when we get it all drafted, but here's what I did. I'm gonna strike all language requiring publication, but say that it's posted on boards and electronically in the customary way, something like that.
Well, I wonder if you could say, that, you know, public hearings will take place, at regularly scheduled Board of Adjustment meetings, and notice for those meetings will be held in a similar fashion will be given in a similar fashion to, council and planning commission meetings or something like that.
There aren't any
I was thinking the same thing. All of these hearings are going to be conducted during regularly scheduled meetings. I mean,
For the planning commission, not the.
I can't imagine that there'd be,
In big cities, maybe they schedule special stuff, but we won't be doing that.
Well, that's because we're gonna be the same group, right?
Yeah.
But as soon as you appoint 3 other individuals, they're gonna have to have their own meetings at a different time.
Well, they can follow the same rules we can
but they
follow.
Right,
would still
they have
have
to.
they would still have their regular meeting
Right.
scheduled.
Well, it says the board shall fix a reasonable time for the public hearing, so. We don't
Unless
spell
it's
out.
prohibited, there's no reason you couldn't have a public hearing. I mean, even if something needs to come before the city, we could have a public hearing
Mhm.
on the agenda.
Yes. It'd be a separate meeting on the same day, a little bit different time, but the same location, same day. So, like you suggested way back when, we had a city council meeting, can we adjourn and re-adjourn as the planning commission? It'd be the same kind of thing, we'll end the one meeting and start a new meeting.
Yep.
And it'll be under a different title, the whole 9 yards.
And I think we adjourned that one, but really you don't have to. You can just recess as the city council or the planning commission and go to a hearing.
Okay.
And then adjourn that hearing and reconvene the city or whatever board.
If we're all the same body.
Yeah.
Okay. We can work out the mechanic. At the bottom of that 7, you know, we're talking about telling the people about it through publication, we're gonna do it differently. I wrote for myself a question, do we want to decide about additional notifications like signs on property when we're talking about the hearing? Because the notification is a little bit, there's more about that later on in here. But about the hearing itself, is this enough?
I like the idea of having signs that you could put out. I don't know what that would cost.
Well, that's
It doesn't
required.
cost us anything, we can make
Oh, they
the
would-
applicant pay for it and do it.
That's what Eureka does. They just make their, when you apply for an appeal, there's a fee that generally covers the cost of.
That is certainly a good way to notify the neighbors who may not be on social media or anyplace else.
Because the next section 2 talks about evidence of the notification of the adjoining property owners. The applicant shall present evidence to the official that he's notified the property owners with certified receipts and return receipts of letters. But do we want to do signs as well? That's why I made the question. Is the letter enough and our notice enough that that's all we need, or do we going to have the petitioner also put up signs?
They have to do a certified letter, I guess you may not have to do a sign. Although, would that certified letter go to a non-resident property owner that has a lot next door to them?
Well, that was another question I had. Who does it get mailed to? The property owner or the person living there?
No, I mean, if it's a renter, why would they care?
Would have to go to the property owner.
And we need to spell that out.
Yeah, I mean, in our case, for sure.
Well, it does say property owners within 200
Right.
feet, so they are covered. That's
Oh.
inside, yeah.
You're not talking about that many people.
I think, you know, evidence of notification of the neighboring property owners is sufficient. I don't think we wanna
Need a
put
sign.
people through the expense of having a sign printed,
Okay,
posted in their yard.
all right, I took my note off. Okay,
Well, let me just make one other point. Is the law, if the law says that the sign needs to be posted, and again, the only person I talked to about it is Eureka, and they pay for the letter and they pay for the sign, and, I mean, it's a wash. They make the application fee for an appeal to cover that cost.
And how we gonna? So the person requesting variance has to publish,
yes,
send a letter to all the people within 200.
yeah, the applicant has to
And
mail
if they
the
don't, and if they don't do that, then you throw the appeal out.
They haven't met the requirement. They won't even have their appeal hearing, because that all happens before the hearing.
Right.
They'll be removed from the agenda, because they didn't do their stuff.
Sounds like that's also people that back up to them too, because it doesn't exclude the back line of the property.
Well, it's
If you
supposed to
put
be,
a-
I think, anybody within 200 feet of said variance.
Oh, the boundary.
Boundaries, it says.
So it'd be front and side and rear.
I mean, is the purpose of putting the letter out and putting the sign up to see how many people you can get that don't like the variance?
Yeah,
The purpose is to notify the people next to the variance request. That's the
If you
purpose.
If you put a sign up, then a lot of people outside of that 200 feet are gonna be jumping in.
Well,
yeah.
and they can read our notice too, because our notice has to say who's asking and what they're asking for.
But you're right, that's the
If
extra
you,
that
I
the
mean,
sign does.
if we have a public hearing, then yeah, any resident could.
Anybody can speak up. It's not limited to people within 200 feet.
So,
200 feet from the.
so it depends on,
That's, that'd be twice the depth of your lot
Is
typically.
that house 200 feet? I mean, that,
Oh, yeah, it's inside that, yeah. Yeah.
it's within 200?
That's
feet?
100 feet across the street from
Okay.
here. 150 at the most.
so,
I mean, there are gonna be instances where there's nobody within 200 feet of the house in some of these.
Sure.
but if you put a sign out there, somebody might,
Well, I mean, that's,
But there are property owners, probably.
no, all the lots are at the state.
Well, not anymore, they aren't.
Anyway, I
It's
mean,
not likely that those are the people that are gonna be
Yeah, they
asking
are.
for variances.
That's right.
yeah, it's gonna be residents.
I think the sign would get more attention if that's what you're.
I see no harm in doing the sign if they have to pay for it.
Might discourage you from.
It's gonna cost, what, $35?
No waiver.
If they're gonna pay for it, but who does it?
We should do it so it's readable and
Who's we?
the
Planning
Board of
Commission.
Adjustment or
we you?
Planning Commission.
Or the building
Is
inspector?
we, you, or
Or
is
the
it
building
Dan?
inspector,
Or
yeah,
is
the
it
building
Ben?
inspector is gonna put it up for us.
Building inspector isn't the code enforcement.
Or the code enforcement, yeah, whatever.
Well, you just have a
Code
general
enforcement
sign
trains
that
the
there's,
people to pick their trash up.
there has been a request for a zoning variance or whatever variance. And, you know, you probably get several printed and send them one at a time.
Yeah,
And then the letter would give the specifics of what it is.
yeah, that's a good point.
Have a generic
Have a
sign.
generic sign, absolutely.
See the website for a hearing that's scheduled for a variance request.
Yeah.
Simply
Yeah,
red, white, and blue.
that's a great way.
The one I saw in South Carolina in somebody's front yard, so obviously they require it. It was a metal frame, a permanent metal frame, with a permanent metal sign on it that had a place to erase, you know, a grease pencil where you wrote in the hearing date, and it just said generic, the owner of this property has requested a hearing on a variance, the hearing is scheduled for such and such a date. And that's, you know, so you didn't have to get a sign printed every time. It's just, you know, the city had a few of them, and, you know, you write the date in of the hearing, the date and the location. Well, the location can be printed on it. All you gotta do is write in the date.
You could say, see the city website for the date.
Yeah. That, I could go along with that, because I don't wanna get into something where every month, somebody representing the city has to go to Wicker Walker and have 6 signs made.
No, I agree.
No, you,
I
I mean,
think it has
you
to be
get,
a generic.
I mean, I don't know how many, but I mean, your idea will work as well. 'Cause initially it might, I mean, if we end up having, you know, a dozen,
You're not gonna have it.
you never know.
I think we're going to have lots of
And
variants.
that's why I think it's gonna be a lot more expensive to have, we've got 6 or 8 variances, hearings in a given month, and, you know, we've got, you know, 4 signs or something.
To help with the sign language, it's down in F on page 61, when it's talking about when you want to change the regulations, what, we have to post signs. We have to post signs if we want to change the reg, but this question was about variances. So, it says, the applicant shall post notice on a weatherproof sign provided by the city, place the signs on the property that's subject for the application with at least 10 days before the public hearing. Ensure the signs remain continuously posted until the final decision is made. One sign shall be posted by the applicant for each 300 feet of street frontage, up to a maximum of 4 signs. Signs shall be placed along each abutting street in a manner that makes them clearly visible to neighboring residents and passers-by. There shall be a minimum of 1 sign along the abutting street. So that's in the section F under amendments. We haven't gotten to it yet.
I think a generic sign, we gotta put that many up, just a generic
A
sign.
weatherproof sign provided by the city is what it says in here.
Pre-print them and
Like
have
what you
stack
described.
them.
Yeah, you can get coded signs, but they don't have to be colored.
Ooh, black and white.
Yeah.
Just black and white,
Weatherproof. Weatherproof.
call attention to where the specifics are on the website.
Or even that core plastics,
It's weatherproof.
Yeah.
cheap.
Permanent. So I can copy this text and put it up with what we've been talking about.
Why was it under amendment?
It's in the amendment section. When we talk about amending the regs.
Oh, that you have to advertise that.
Yep. We'll copy that and paste it up here. Oh, what section were we in, guys? Help me. Administrative officer.
263,
I thought it was 263,
14,
but I've got.
dot 263,
We're in
page
263.
57.
All right.
The hardest part about posting a sign is
Getting it in the ground.
getting it in the ground, exactly.
If you
We
use
should get
rebar,
some of those heavy-duty sign holders
you
then.
got rebar on the, it'll go down.
When I put my signs up for running from there, I took a piece of rebar and a hammer with me and made holes in the ground
Yeah.
That's the way
with
you
the
do it.
rebar and then just set my sign in it.
Sometimes you'll hit a rock though, you have to, can't
Well,
get through the rock.
Pick it
I
down.
bought a $6 16-inch rock drill. It worked good.
You have a rock drill?
It's
Wonderful.
3/16 or 5/16 diameter.
Oh, we know who's gonna be putting the
Yeah,
signs.
you're elected.
All right, so I inserted this after 2, so that'll be the new 3.
How much do you have to pay for such?
Oh, they're like $10.
10?
Yeah.
To go through rock?
Uh-huh.
Well, the building inspector.
It'll only go through one rock and then you have to buy another one.
I'll bring it to the next meeting. It did about 10 signs. Okay, so I inserted a 3 and moved the 3 down to 4. And the applicant shall post notice on weatherproof signs provided by the city, place the signs on the property as subject for the application at least 10 days before the hearing, and ensure the signs remain continuously posted. One sign should be posted for each 300 feet of street frontage, up to a maximum of 4, and placed along the abutting streets. So that's what I inserted under B2. We'll see how it fits. Okay, and again, there's in 4, this new 4, it needs to be published. I'll be changing that text. Change that font to strike out.
Well, there's one issue here that's still got a pulse again.
Okay.
Because when you read something earlier, you said that it needed to be in a newspaper published.
Yeah, that was about ordinances.
Okay,
This is
but
about
this says-
hearing notices.
This is, they call published at least once, so and so and so, in a newspaper of general circulation. That's different than published in the
Where are you reading it?
In B1.
B1.
What?
You're right. It's different than published in.
Oh, of general circulation, it does say.
Yeah, and I don't know what the definition is in Arkansas, but in Oklahoma, general circulation meant that you needed to have copies delivered in that town.
Well, I thought we were just gonna strike this, cause it's not required by law. All that blue,
Is it not required by law?
it's only required for ordinances.
In the section I read, yeah.
I think Town just stuck this in their code. They probably have a newspaper.
Okay, all right, never mind.
I agree. I did do it because they have a newspaper, was my guess.
And didn't, just to follow up on that, didn't you or somebody told me that it also has to be published twice a week, and the Carroll County News is only published once a week.
It's true.
No, that wasn't me.
Somebody told me that.
That may be, that very well could be true.
Yeah, they,
I mean,
sometime in the last
it
year,
just
I think
depends.
it's
In Oklahoma, it's got a general circulation, means that it can't be free. Because that was written when a guy, legal notice is big money for newspapers. So a guy in Enid, Oklahoma, bought a small press.
Mimeograph machine.
The equivalent of a mimeograph machine that he cranked out, and he undercut all the rates. And, so anyway, they rewrote the law. You had to be a general circulation newspaper, which was defined not free, and more than 50% of your circulation had to be paid.
and the legitimate newspaper organizations lobbied for that, I guess.
Yeah, absolutely.
Well, they tried to get it changed in Arkansas this year. No, that wasn't that. It was the Freedom of Information Act. They tried to get some FOIA stuff changed in the newspaper lobby, shot it down. They wanted to be able to digitally or something provide information. That shot down.
Okay, we're still in 263, and I have E at the very end highlighted as a concern. Appeals from the Board of Adjustment. Any person or persons or any board, taxpayer, department, board, bureau of the city aggrieved by a decision of the Board of Adjustment may seek review by a court of record of such decision in a manner provided by Arkansas law. So I guess if it's provided by the law, we can't say it shouldn't be here.
By a court of record, would that be
Do you like
Be
that?
like I don't know what court
Circuit
record,
court.
what's the circuit, yeah,
district court?
probably.
Like
It's
district
not,
volunteers
it's not
traffic
Judge
fine.
Judy.
Yeah, it'd be circuit court.
Well, I think people would probably sue even if this sentence weren't in there, don't you?
But I don't think it's gonna hurt you, I mean, cause they could do that anyway.
That's what I'm saying.
Well, the exception is what was changed in 1456-416 in the last legislative session. They added a section that says, except as provided in the subdivision, blah, blah, blah. In this section, decisions of the board under this section shall be appealed to a court of competent jurisdiction. And then B, a governing body of a municipality may provide by ordinance that the governing body of the municipality shall first hear appeals under this section.
Really?
So it said in that, and that was a change they did in the 21 session, that if you don't like what the Board of Zoning Adjustment says, you have to come to the city council before you can go to the court.
Well, that ought to work well.
But we need an ordinance that says that.
Well, you change E to say appeals from the Board of Zoning Adjustment shall first be presented to the city council or some wording like that.
Well, that's our procedure. If we go from
But it
building
doesn't, it
inspector
doesn't
or
say that.
administrative officer to planning, not to board of adjustment, to planning commission, to the city.
Okay, do we have that as in our ordinance, Dan? Does our ordinance spell out the city is after the Board of Adjustment?
In the building code or?
We don't have a building
We don't
code.
have- We don't have it in an ordinance. yet.
Right, we don't have it in an ordinance,
But
but if we
this
put it
would
here,
put
it
it
would be.
here.
We have a building code.
We did the building code
Yeah, but-
last month.
This is different than the building code. So.
Okay,
Yeah,
We
just
don't-
change that E to say that.
okay.
Yeah, put it in there, and then, I don't know that we would, if we put it in here and then pass this as an ordinance, I don't know that we would need another
I don't
ordinance.
think we do.
Right.
Yeah.
And
Yeah, I mean,
not the wording
the
basically
suit should
out of
be
that
against the
statute.
ultimate authority.
So,
Yeah,
Which is city council.
Okay, so any person or persons or aggrieved by a decision of the board that may seek
Review by the city
review
council.
by first appeals.
City-
Okay,
appealing to the,
first appeal would be to the city
City
council.
council.
the
After that, they just
First
go
year
civil,
appeals.
They have to go to civil court.
hear appeals by or to, or was the right verb?
first appealing to.
To the city council.
Seek review by the court.
Okay. And then once my transition, then to a court,
Mhm.
How's it worded in that statute?
well, it doesn't say anything about the court.
I thought it said,
Shall be appealed to the circuit court of competent jurisdiction.
first appeals under this section. Yeah,
I'll work on it. Alright, we got the city council.
you
then
could say
first.
city council, then whatever that word is, court of whatever, in that order.
Okay.
Certificate of occupancy. No, that's not next.
Competent jurisdiction.
Yeah, the back of the administrative officer, that's not, we did that a while ago.
Alright. Anybody wants to do the minutes of a 3-hour meeting, you're welcome to it. It's a lot of fun. Okay. That's it for that section. Administrative officer. I'm gonna change this name then to building inspector.
Right,
Yeah. And then you can strike the next part that says under the direction of the building zoning official who is the building inspector.
Yeah. So I'm just taking that under the direction of, out of there. Okay? Okay,
We don't need that.
I don't even know shall act as either then,
Right.
because it's the building inspector. It's the duty of the building inspector to see that these regs are enforced. Appeal from the decision of the building inspector may be made to the adjustment. The building inspector and his designees, is he gonna have any?
Maybe someday.
Okay. All right, that's the only problem I had in that whole section. Or concern. All right. Dot 281. Building permits. I'm reading down through this of what he has to do, and I remember at a couple of, well, at least one planning commission meeting that I attended, I heard Mickey Finefield say to a guy, how high is this from the point on your lot? We need a topographical drawing. Where's it at? What in his stack? So I added in this B after the word, in the next to last line, areas, drainage, comma, topographic locations and dimensions of heights of structures. So that someone would tell us where that street is, where that lot height is, because we have a requirement not higher than 30 feet above the highest point of the lot.
We gotta make sure that that's compatible with the building code, because there's very similar language in the building code as to what's required for a building permit.
Okay.
And, I don't think topographical map is part of the requirements, and I'm not sure that,
Says a plot plan, a foundation plan, a floor plan, all elevations and partial elevations drawn to scale, indicating all openings and materials to be used. Elevation drawings will show the relationship of existing and proposed grades to the house.
So elevation drawing, I call it topographic.
an elevation drawing doesn't mean like 5,000 feet of elevation. An elevation is just what does the side view of the structure
true.
look like.
On architectural drawing, that's right. Yeah.
So, and when they,
But it would have the height from the ground.
It does, but it doesn't, but that doesn't reference the lot in our requirement that no structure is over 30 feet above the highest point on the lot.
Ah, so you have to know
That's
the
the
whole
topography, right?
lot.
So if someone has an elevation that shows 35 feet on it, you have to know where is it going to be on your lot and that highest point to know that it's going to be compliant or not.
They
Without
probably
that
aren't
reg-
even doing that today.
Well, Mickey asked this builder for one. He says, where's your topographical at? How high is it going to be?
But Mickey may have asked, but it's probably not in any official regulation. They do things unofficially anyway.
Right. But when we have a reg that says it can't be over
Sounds like
30
you
feet,
may need it.
the topographic location and dimension of heights of structure.
Those are not hard to get. You can pull those off the internet now, can't you?
Well, I can do it with my cell phone. That I know the corner of this lot is at elevation 1062, and I'm gonna be 100 feet from there, and I stand there and it says my elevation is 862, okay, I'm 200 feet below that point.
So why would
And I could draw that on a piece of paper.
why would the person seeking the permit need to provide anything? Couldn't the building inspector just get out Google Maps and do it?
Well, they would force him to do it. The goal is that your applicant brings you all the information for you to
Yeah.
analyze.
it's not the building inspector's job to produce you know, the documents required for approval. I don't see it being a problem if somebody wants to build a new structure. Again, I'm concerned about how generalized some of these statements could be applied. Like if somebody just wants to add on to their patio, do they have to have a type of topographical map?
I would,
It's gonna cost them
for this requirement, I'd have it.
$250 from a surveyor.
What I would provide to you is a 8.5 by 11 sheet of paper that's titled Dumas Topographical Map, and I draw my line on, draw my patio on the ground, and say, here it is. If that doesn't suit your need, then maybe I have to spend more money. But I'll supply you the map you need. It might not be the quality that you want.
I think as long as we allow some discretion on the part of the building inspector as to whether or not it's even pertinent. If they're doing an addition to their house that doesn't extend vertically beyond the structure that's already there, then it's an N/A. If it's a new structure, maybe we do need that.
Well, can we write something in there that says, topographical, map, if requested by the building inspector?
Sounds reasonable.
Here again, the way we want it to work is that somebody wants to build something, they print off the check sheet from our website that says all the documents they need to provide. So they get that, they start gathering their documents. At the next regularly scheduled meeting of the building inspector, they bring all those documents and they leave them. They don't sit there like they do today. They don't sit there while Mickey and everybody goes through all of their stuff, and then they issue them the building permit on site. The building inspectors can have 7 days to go through all those documents and then either issue a permit or call the person and tell them what they're missing.
Okay, well, I mean, that would work if he says that, you know, I'm gonna need a topographical map, or.
Because based upon your request, we need to see that
Yes.
topographical map. In most cases, we won't need to see it, but some we will, so he can ask for it when he receives everything else and sees the request.
I tried to avoid these topographical map, so it wouldn't require a survey, but a topographic location and dimensions, I could do it freehand on a piece of paper. I got a sloped lot and I build a house and it shows here and here and the distance is 20 feet. Topographic location and dimensions rather than a topographical map.
Okay.
That was my intent.
I don't have any problem with that.
Sounds good.
There ain't no way you
But like Dan says, it's not his current building list.
That's okay. I mean, they still
Doesn't
have
be a change.
they still have to meet the rules of the
height.
the heights and all these things that are in this code.
As long as there's some flexibility to where, you know, the building inspector can either decide whether a map is required or, I mean, it may be that the building inspector knows the lot that they're gonna build on. It's in the bluffs, it's all flat.
Mm-hmm.
And the house is only gonna be 24 feet tall, so.
Yeah, I mean,
No problem.
that's a good point. Once it goes out there, you know, if it's built, you know, down a long driveway to the bottom of the lot, you know, if the house,
have to have a
has to be 100-foot house, so, yeah.
Yeah, why make them do extra work if it's not even necessary? So.
But I think we need,
So you want some judgment in here?
well, I think we need language that makes it, gives him discretion if he needs additional information that eyeballing it doesn't work, that he could ask for, at the very least, the elevation, whatever your document would be called.
The minimum things are in the, required in the building code here to go through the permitting process. But after you get into the permitting process, there may be some other things.
Okay,
to ask
no,
for.
here we go. Let's do this. Copy this. And put it on the bottom. Paste it there. Okay, so what I'm gonna suggest then is,
Well, it
taking
says
the
there,
Alvar idea,
it says, and any such other information that is necessary to provide for the administration of these regulations.
right? Semicolon, such as, but not limited to,
Topographic,
drawing. A, there we go. Got it. You're on the same page I'm on, Ken. So I put at the end of this, such as, but not limited to, a topographical locations and dimensions of heights of structures. So that gives you the discretion.
and we want to be discreet.
That horse is dead. 282, certificate of occupancy, other than the title of the building official, change it. In the B, the procedure, a certificate of occupancy shall be applied for coincident with the application of the building permit. Do we want the certificate of occupancy application made at the same time they give us a building permit? Or do we want them to ask for it later?
Later.
Oh, you
They're
have
gonna-
to inspect the property after it gets built.
Right, but
Says to have
the
it.
application for the permit, when do you want that to come? The application for the certificate, rather.
Why
You want
is,
to apply for it, but at the same time they apply for the building permit. They don't get it right away, but do they apply for it at the same
I
time?
don't think there's an
So
application.
it's part of the record.
I don't know that there's an application for a certificate.
No, there isn't, because the current planning commission didn't issue occupancy permits. And in the recent history of Holiday Island, it's only been asked for one time, and that's because somebody was getting an FHA loan, and the federal government required occupancy permit before they let them complete the financing. That is a big open issue for me yet, that I have to resolve, because I don't know if your building inspector, or if our building inspector has to be a licensed building inspector in order to issue an occupancy permit.
Isn't that why we went to Green Forest to get that one? Cause he
Well,
was
yeah,
licensed.
because we didn't, because,
Or maybe the FFA required him to be licensed or something.
no, the current planning commission would not issue an occupancy permit, because they weren't licensed building inspectors, and they wouldn't accept the liability of, because they didn't actually do any inspections, they didn't want to accept the liability associated with
But
the
our
house
person,
possibly not.
our person is gonna do inspections, right?
Yes.
Our person will be doing inspections, but I don't know if you have to be a licensed inspector in order to issue an occupancy permit. I haven't found that out yet.
Well, is the difference in occupancy permit compared to a certificate of occupancy? Is it illegal?
Occupancy.
We talk about certificates of occupancy.
Right.
We talked about it in the building code, and I'm still trying to find that out, because it makes a difference as to what kind of person we hire.
Yeah,
If, if cities our size regularly issue occupancy permits based on inspections done by a non-licensed inspector, then that's probably what we'll do. But if, I need to ask Butch Berry, I need to ask Tim McKinney what they do. Green Forest, we know, has a licensed inspector, and I was told,
So does Eureka. There, he's a licensed building inspector.
Well, I have to confirm that. I've been told by people that he's not, that he was a licensed plumber, because he used to have a plumbing business.
Okay.
And he was a licensed plumber in the state of Arkansas, but not necessarily licensed to do electrical inspection, foundation inspection, and all of that kind of stuff. So, maybe he is, but back when Holiday Island needed one, they got the guy from Green Forest, because I was told, because he was the only one in Carroll County that actually had a license.
Well, then maybe we don't issue a certificate of occupancy, but a certificate of completion.
Just copies of the signed off inspection.
You just need to find out if state law
Do you have
has
to
the
have
word certificate of
do you have to have a
occupancy.
certificate of
It's on my to-do list to find out, because, I have a guy that might be interested in being the building inspector, but he's not necessarily interested in doing, taking all of the courses required to be able to take the exams required to be a licensed inspector. So, there's a big gap between just somebody that knows a lot about construction and being a licensed inspector. And I need to find out what other cities normally do.
Go back to my original question, this B, this sentence, I think we need to strike the sentence B, because up in A, the last sentence says, a certificate of occupancy must be applied for and issued by the building inspector prior to occupancy and use of the structure or premises on any of the following. And then it goes on below B, there's a timeline that once you apply for it, you only got 5 days to respond to it, or that timing doesn't work. If you give me an application for occupancy, when you give me an application for building the structure.
Right.
That sentence just
You
has to
had
come
4
out.
days to build the house.
Yeah, okay. I'm striking it. It doesn't make sense.
Yeah,
All right.
The certificate of occupancy would be when the building's done.
Yes. And that's our only holdout to say, you can't get in that building yet because you didn't fix the problems I pointed out 4 months
exactly.
ago.
And that's, like you said, that's the leverage that cities have to be able to get something corrected. If the pressure test of the plumbing showed that it leaked like a sieve, they don't get an occupancy permit until they fix it.
What prevents them from moving in anyway?
Well, if they do, then we note that, and then we've got a violation, and now the fines.
Well, I don't know, the old HICPC code said they wouldn't turn the water on until you get
Yep,
certificate of occupancy.
we've turned the water on while they're building, it sounded like.
Not in the house.
In this one, right? In Dan's document?
I thought we allowed them to have some water while they were
You
building.
can have a construction meter.
Construction meter.
You can't turn the water on into the house.
Is that just an outside faucet?
I guess I haven't figured out what a construction
Okay.
meter is yet.
Okay.
I don't know,
That might
I remember
be the
that.
But it says HICPC can put one in, so I need to ask Dan if he's
Yeah.
ever put in a construction
I
meter.
don't
In
know,
Sioux City, when I filled my pool, I had a construction meter hooked to that hydrant so they could bill me for the water.
Yeah,
It just, bolts onto the water system.
that's what I figured, that they,
Kind of a
while
temporary.
you're building the house, you
So
need
you can
water
get the water.
to wash down the cement truck or whatever,
Keep the lot clear.
To make cement.
Yeah.
So you have water on the side. Other than that, that's the only problems or questions or concerns I had, other than changing the name, building official to building inspector.
Mhm.
okay,
Amendments, 283.
Whoa,
In number 2, the building zoning official may be, or shall be responsible for scheduling the hearing. Is that who we're gonna have do that?
why is it called amendments?
We're talking about amending the zoning regulations.
Oh, the process for
This
amendment.
document,
The
right?
process for amendment.
well, that,
Lynn will incorporate these into the proper place in the code so that they don't have to start out being amendments.
No, right. Each one of these sections will be part of an ordinance and become part of the code. But anyway, the building zoning official, the building inspector shall be responsible for scheduling a public hearing.
Chairman of the planning commission should schedule.
It says here.
The public hearing before the city planning commission.
I would say that the building official, the building inspector shall notify the planning commission of the need for a variance, and the planning commission will schedule the hearing.
This is not about variances.
No, this is
This
about,
is a
this is about
About amending
changing,
code.
changing the zoning regulations.
Changing the zoning.
Amendments, section A. Two types of amendments to these zonings are recognized, one being the revision in the text, and the other being a change in the boundary of the district.
Why isn't it just a change to an ordinance? Why
It is.
have a special paragraph called amendments?
Because this is an existing document that's been around for years.
Yeah, but it is city code, it is municipal code
Right?
in
That's
its
true.
current form.
Yes,
Yeah,
it came from the Muni Code.
Title 14 zoning regs.
yeah.
Wouldn't you amend it with an ordinance or something?
Why does it have to be part of the planning?
You're saying, why didn't they just amend section such and such
In
of,
an ordinance.
Title 11 or whatever?
I mean, I don't get this different process for amending this.
I haven't researched the code, but maybe the code says your planning and zoning needs to have hearings. It's that same horse we've been talking about. What's a hearing and what's a normal meeting?
No, this says you gotta have.
You can't, this says you can't change it without having a hearing.
Well, planning and zoning would be discussing, the commission would be discussing any change
Right.
in the regulations that they created. And, because I think it has to be implemented as an ordinance.
It is, it will be. That's how it gets into our
So
code.
why aren't we just using the normal ordinance process for changing it? We have it on an agenda for a meeting to talk about, the public gets notified that this is a subject on an agenda for a future meeting.
Well, again,
I don't
because,
get it.
again, well, in section F, it talks about you gotta give 15 days notice. We don't do that necessarily in our meetings.
Yeah, this is
This is
just
special.
describing the process.
So you're saying
It's
a little special process because they're,
because it's
Zoning
zoning, yeah.
But I think what Dan said is the way to go, that the building inspector recommends to the, or says we need a hearing on this, and the chairman of the planning commission sets that hearing.
Well, it says it.
This is what this is describing in 14.283 is how to, it's a process for changing the zoning ordinance. Is really all they're trying to do here.
But Lynn's question was, should the buildings official be the one scheduling the hearing?
No, and we resolved that, I think. I wrote,
Okay.
shall be responsible for notifying the planning commission chairman to schedule a public hearing. And then the he needs to say, the building inspector shall prepare the content. No, we can't. Who is the he? Who's gonna prepare the content for the public notice and publish it in the paper?
Says the building inspector.
I know. Is that what we want him to do all that?
No,
Nope. How about the planning commission secretary? Or the chairman? We're looking for the title. Who's gonna do it? Somebody has to write the documents and get it in the
I think
paper.
you got
or-
the two people that could possibly do it, that you just named.
I think the planning
Chairman or the
commission,
secretary,
planning commission.
or the chair at the designee. I mean, 'cause
Comma, vice chair?
I mean, that's what, if that's how he wants to do it.
He could delegate it, the
Yeah, I mean, because we
chair
could
could
use that
delegate
term, or his or her designee in several places.
Okay. I like that better.
If you just made the mayor responsible for it, I mean, that doesn't even need to go in.
He's got broad shoulders.
Okay.
He's starting to slump a little bit though.
Do we really need that section? I mean,
That's what Linda said.
That's
do
what I
we
said.
really have to be this formal and this legal and this
I don't think
anal
so.
about,
I don't think
if
so.
somebody wants to change the, you know, some little bit of the zoning, of a zoning ordinance?
I mean, all you're doing is duplicating what you already got
Yeah,
required to change an ordinance.
this looks like something that's out of the New York City.
Some damn
Well,
boy.
we know it's from Tantytown. I don't know where it came from.
I think
Yeah.
it should be
It
just
came from
You
normal.
know that Tonytown didn't write this.
It's a normal course of business.
No, I'm guessing
plan.
some attorney did.
Attorney wrote it.
Yeah, but he cut and pasted it from Little Rock, who cut and pasted it from St. Louis, who cut and pasted it
Oh.
from New York City.
New York City.
Well, I wouldn't give it to New York City.
Yeah,
Maybe.
exactly.
It
Okay.
just seems to be way overboard
Let's take
for our little bitty situation here.
14,238 out.
Well, unless you do what Linda recommended, just say that, about, you know, following the precedent we've set on amending ordinances. Isn't that what you said?
Well,
Yeah,
for
well-
me, we're gonna be amending ordinances from here on a variety of things.
Well, you can put a simple statement in there to be accorded.
And in fact, the city
Amended and
council is
sent.
responsible for amending ordinances.
But if you're gonna
Now, so, I don't know, maybe
You're
this is
changing-
to
if
get
you're-
the planning commission involved before the city council
I don't know, if you're changing,
writes the ordinance.
if you're changing how you zone property, then you could have to have a public hearing.
Yeah, and do you do that at a city council meeting or do you do it at a planning commission meeting?
It's a planning commission.
Right, so you gotta have something in here that the planning commission
So,
is
yeah,
involved in.
make this just say that any amendments to zoning regs will be first processed by the planning commission. Be done.
Following the public hearing.
Yeah.
Regarding the proposed amendments.
Yeah.
And make known to the city council. That's paragraph B.
Okay, maybe that's all you need.
Well, this goes on forever and ever and ever.
You know, the lawyers.
And then it talks about the
charge
city
an hour
council and
before
C.
they type, and before they can charge.
They got some clerk doing all this, copies.
It's spelling it out.
Yeah, I don't think you need all this
Okay.
rigmarole.
Yeah.
Just say
We
it's
need
up to the
finish
city
this.
planning commission.
What about the last sentence C? If the city council action does not take place within 3 months after the commission public hearing, the amendment process must begin anew. In other words, one way to kill a thing is not do anything. Don't even have to make a decision.
And I think they
That's
got.
the most effective form of government.
It's done in government all the time. The governor lets laws go into place, he doesn't approve it, he doesn't deny it, it just goes into place.
Well,
It goes in place, this one says
the
it could start over.
council could always table it, and it could die that way.
I think you're creating a whole set of rules and regulations on one thing that we already know how to do.
I think all we need is B.
You don't need 2 more pages of it. It duplicates, stuff we've already done.
Yeah. First of all, our hands are somewhat tied to change the zoning anyway.
I disagree, but that's okay.
I said somewhat.
I would just make it B and C and,
I'll just,
strike out the last sentence, if city council action does not take place. Because they can just take a look. If you think that makes sense.
B and Z, keep those two sections.
I don't know, the last part, the whole last part of that has to
Make it as
do with
general.
changing zoning.
This is why we talk about it.
I mean, amending the regulation or the ordinance is different from changing the zoning, isn't it?
No, because we approve both by reg. We approve both by ordinance. I think you're right.
And then you got change
This
in the
is just
district.
way too much for our situation here.
Change in district boundary, and
That's changing the zoning boundary. District and zone, they use the word district instead of zoning.
which is,
We'd still do that by ordinance.
So we in agreement?
Yeah, I just made a note that we're gonna keep B and C, and took out that last
B
sentence.
and C and with a little editing,
Yeah,
and just skip the rest.
there, we got it. Taking out A as well.
and it goes into the signs and all kinds of crap.
Yeah, what else?
And under 284, if we're going to, if somebody asks for a change to the regulation, I guess we could require a fee for doing that, but, I don't really see the necessity for that.
Well, I just wondered, do we wanna have that? I made a note, this fee is different than 14,240.
Mhm.
It's a different kind of a fee.
Right.
At least the fees and the penalties, that's not applicable to the amending the ordinance, is it? This is,
Well, this 284 talks about you're gonna charge a fee for someone asking to change the reg.
In other words, if I wanna get my lot rezoned, I can make a formal request, but it's gonna cost me $100 or something.
Because they have mapping and whatever.
Yeah,
So far, that doesn't cost you anything, but someday you're gonna have to pay for it.
so you could just say reserved. So someday we might wanna have a fee associated with it.
So we decided 284 will be reserved, Linda. We're not gonna charge a fee for someone asking to change the zone on their property.
284?
Yeah.
I skipped over to.
We're on page 62 in my notes.
that sounds good.
Says
There's
14
fees
dollars.
right here.
Oh, it's up in here.
Yeah. Caught my mistake. We're gonna reserve that.
Reserve, okay,
We're not gonna charge a fee for now.
okay.
For zoning requests. Okay, in .999, the penalty for violation. That was on my to-do list, I think, to find out if the state statute permits these dollar amounts, because these are huge. I found 3 statutes that don't directly address it. But they give, in 55-601, the power to enforce generally, that fine, penalty, forfeiture may be prescribed in each particular bylaw or ordinance, or by general bylaw or ordinance made by, for that purpose. It says we can collect fines and penalties and forfeitures. In 605, it says we can sue to collect them. And in 607, and additional remedies for cities of the second class. In all cases of violation of any ordinance or any city of the second class, in addition to the modes provided by law, shall have the right to recover in civil action the amount of property, of penalty, and fines provided by the bylaws and ordinances of these cities, or imposed by the mayor thereof for a violation of any ordinance or bylaw. So I just found permission that we can do it. I didn't find any dollar limits.
Well, these are not to exceed dollar limits, so I don't see a problem with it.
But there are some statutes that you can't charge more than $100. There's some that you can't charge more than $125. I was looking for violations of city ordinances if there's a limit. I didn't find one.
Yeah.
And those were the amounts in the tiny town.
Yeah, I just marked them in blue to highlight them.
But they're not setting any penalties for these in this paragraph anyway.
No, it's just that the seat can't be more than $500.
We'd
So,
have to set
so when we
penalties
say
by
the
law.
penalty is $25 a day, in 20 days it stops.
Where
Well,
does it
unless
say
the-
stops?
It's whatever
What's
the
the
fees and
penalty?
penalties he has in this document, it
Oh.
limits in 99. The penalty limits be punished for a fine not exceeding $500 or double such sum for repetition thereof. And then the next sentence, the penalty for allowing the continuance thereof, the fine is not to exceed $250 for each day.
So these.
So I guess it is $250. It is a daily thing.
So Title 14 zoning regulations refers back to Title 11? Where you saying?
No. Do you have fees and penalties in this
There
document?
is fees and penalties.
I don't recall.
Yes.
Okay.
That's
So-
for starting work without, that's for starting work without a permit,
It's
right?
not violating, there's nothing in here about violating any zoning stuff. though.
Right, yeah, that's in here.
Okay.
And hopefully they wouldn't be to this point if they had if they were in violation, because no one would have given them a building permit.
But that's kind of the whole point.
So in other
If
words, they
somebody-
start building without permit.
If somebody builds without a permit, they get fined according to that. If that building violates a zoning ordinance, they get fined under this.
Okay. Because these are just the fee, permit
Well, that would mean they
fees,
built
Those are the
and
per-
inspection
something
fees,
other
there's
than
no
what the permit
violation
was
fees
for.
in here.
there are somewhere in there.
There are.
And, but I'm not, but be punished by a fine not exceeding $500 or double such sum for each repetition thereof.
That was the only page for fees.
So if they do it,
I'll go back and read it again, but I think there is a,
Because
There are
that's what I
fines.
posted on the website.
yeah, those are fees.
But there wasn't anything else in this Title 11
For violations.
for violation.
Let me go back
I thought
and
we
read
had
it. I think there is.
Promise you there isn't.
It's not a schedule, it's just a number in a paragraph
In a
somewhere.
paragraph?
Yeah, I remember we talked about it.
Yeah,
okay, let's talk about this,
Do what?
talk about this one. No,
I don't see a
Well,
problem.
see, I think
with
they're
it.
tied together because in this document, in building permits, you have to get a building permit to add on or to change it. And this first sentence is talking about who shall build, alter, move, or occupy any building in violation of the detailed statement or plan submitted and approved herein, or hereunder, shall be guilty of a misdemeanor, and shall upon conviction be punished by a fine not exceeding $500, or double such if it's repetition. It's in their code, I just raised the question.
Well, you
Right amount.
could violate a zoning thing without ever building anything, right?
There is a section of
Awesome.
violations here.
Or you, You get a permit to build a house and you build a bar.
Isn't there a paragraph right after that about fines?
Says, should the person responsible for such violations fail to take the necessary action to correct it, the building inspector will notify the city attorney and they'll take, within 10 days, apply for an injunction, mandamus, or other process to prevent, enjoin, abate, or remove said violation. Penalty for violation. Ah, yes, last paragraph. Says, shall be deemed guilty of a misdemeanor and shall be liable to a fine of not more than $100. Again, we aren't setting a particular fine.
Mm-hmm.
Each day such violation is permitted to exist shall constitute a separate offense. $100 a day,
Yeah, that's,
no limit on the days.
That's fair.
Okay, so now, does that fly in the face of this 14.999?
no,
Okay,
because that's building, that's not following the building code.
okay,
This is not following the zoning
Yeah,
ordinance.
you got a permit
Okay.
to build something and you build something different.
okay, gotcha. Cool.
Yeah,
It
you
fits.
better have a big checkbook if you build it wrong and in the wrong place.
Well, the last commission, or the last planning meeting we went to, it's right there. And the one commissioner said, I don't know how I can approve this. Because they want to do something in an area that doesn't have a zone. It's right there, it's right in front of us. If he doesn't get it done in the next 15 days, it's gonna be in front of us.
Yeah.
What's Anthony building up there behind the mariachi anyway? I went to mariachi yesterday. and I
We're
went,
gonna,
huh?
we're gonna stick to the subject matter, you know.
Well,
I didn't wanna gavel you.
that's it.
That would crack him on the nose.
We can talk about that after the meeting, but,
Okay.
yes, I agree. We have to,
We have to get
our
this done.
zoning
Gotta
ordinances
get through
have to,
this.
has to cover currently unzoned property. And you know, fines and fees, fines and penalties are supposed to be punitive. They're supposed to, deter violation. If you make it a slap on the hand, people are just gonna do whatever they want.
But on this, it says not exceeding 500 or double such sum for each revocation, and then 250 for each day, for continuance thereof. So, I mean, shouldn't that be a set fee? And,
That's what I was wondering too.
I mean, who determines that instead of 500, it's 400 or 100?
It could be you made the building inspector mad and so he sets it at 500 instead of 250.
Yeah, it could be the
Sounds rather
degree,
discretionary.
it could be, how egregious the violation is. If it's a trivial violation versus a significant
The
one.
planning commission would, or who would set that? Who has the authority to set that?
I always thought most,
City council ultimately puts it in a reg.
don't state laws give a specific amount for certain things?
That's what I was looking for, and I didn't find it. What about zoning?
And all this is not to exceed stuff.
Well, I don't guess I have any problem with that, but it doesn't specify how that's determined.
Yeah.
Guilty of a misdemeanor, what is a misdemeanor? That's,
Building
That's
inspector could
criminal.
say,
This
well,
is-
this guy's my friend, so I'm only gonna charge him 10.
This is telling the judge what he can fine the guy.
It's not
Upon
that,
conviction, is punished by a fine. This is the judge. The
The
judge has
judge.
this in front of him. Okay, you violated this, it's gonna cost you $1,000 because it was more than 2 days.
so the judge sets the fee.
The judge, this limits the judge,
a misdemeanor is a civil action.
right? It's punished by a fine not exceeding.
I guess we
It's a
could.
bond conviction. So I was kinda thinking it was legalese, but I couldn't find it.
Alright, so did we answer the question of who sets the fine?
The judge, I guess, what they just said.
But it seems like we should have a finding process internal that we don't have to prosecute everything in court.
Well, I don't know, that's what I was asking, what a misdemeanor is a court offense, isn't it?
Yeah, it sounds like you're going to the circuit court
Well,
to get this
So we-
adjudicated.
yeah,
That's because that's what the law says we can do,
Where
to get
does it
to
say
collect
that?
our money.
Where does it say that?
It says we can collect our money in 1455-605, suit for recovery of fines.
That's recovery of fines.
We fine them
Oh.
something, and we get our money by taking them to court.
Well, shouldn't they just be willing to pay us?
But if they say, I'm not gonna pay you,
But what did we set the fine at?
okay,
you still pay it, to the court.
I can understand
This
them not wanting to
yeah,
pay it.
this document doesn't have any fines in it, we have to set them someplace else.
Okay,
Like Dan has in the building code, we have to set one
but that's
someplace
state
else.
law.
I'm guessing that this is,
But this ought to have it in it, seems to me.
yeah, I'm guessing.
You know, I think the only way to find somebody is to issue a citation. And if they opt to pay it rather than going to court, that's just pleading no contest and you pay the fine.
Okay,
But they
but
still,
it needs to be a specific number, it doesn't need to be not exceeding, doesn't it?
Yeah, I agree. Somebody's gotta decide how much the fine is gonna be.
Well, I mean.
Well, does that come from,
That
our
comes-
court case, the
that
property
comes from
owners
the
say,
district court.
you cost me, 20% of my property value. You got 100 people lined up, so that cost is $1.3 million.
I know somebody who has personally talked to people in Town and asked them questions about their code. I wonder if he could call them and say, who sets the fines under
I
14,999?
was also thinking maybe we could check, the code in Eureka or Berryville or, Huntsville or some other town to see if they specified it or had a not exceeding number.
well, the building code fines,
Cause
we can
everybody's
collect
got
them
their
here without going to
Code.
court, right?
under titles like this.
I don't know,
I got it.
asking-
Dumas to investigate how other
The
towns
city
set
attorney
fines.
should be on the
Does-
Zoom call.
You're the only one that can talk to him, so I guess.
I got a to-do on here, always search the documents I have to investigate how other towns set fines. How do they do it? I'm pretty sure they have ordinances that set them.
I think we're at an impasse.
Okay, as far as this text go, that's the end of it, guys, because this appendix is all the charts and tables that I need to build that are relative to Holiday Island.
Yeah.
I left all this in here because it's how they talk about what's not permitted and their graphic is all messed up, so you can kind of see that across the top is A is architectural and R was the equestrian, then R1 was our big lots, and 2, you scroll down a little bit further and you see that triplexes are not permitted in a lot of areas, and duplexes are not permitted, and townhouses are not permitted, and multifamilies, and on down the list. So I need to work that graphic that relates to us, and then bring that to you guys to make sure it's all okay. There's how many hours we met? 20 hours? Plus the time that I've spent on top of it. We got lots to do.
And we appreciate it.
Well, what I was gonna ask is there any way we can form a committee? Would this work side by side with someone else? And I know it'd have to be a public meeting that we worked on it together, but I've got notes, I've got minutes, but there's a lot here to put together.
Well, I would think you could do that. Mayor appoint a committee or the chairman of this commission appoint a committee and follow just all the open meetings laws and what all, and make it a public meeting.
And I thought that might come, I need to go through and take care of all the things I can, and then to work with someone else would be very beneficial, rather than tie up everybody to go through my scratch notes. Did I get this right? So think about that, I guess. But I've got the map to do. We have to have a map to go along with this. I need those covenants that I don't have. And I haven't been to the courthouse yet to see if I can get them. I don't know what I have to ask for. And if we can't get them, we have to decide what we're going to do about those we can't get.
Do you think the covenants were ever filed with the court?
Some of them were. I found one. I found one. And the
Could
ones
we
that you had, some of them have the stamp that they're in a certain book, but I didn't find them in my online research.
Could we put out a notice asking people in the various units, somebody would
If they had a copy of their covenant,
have a copy of the covenant?
the problem I have with that is, it's going to be the same problem I have with what we do have. It's the latest one that I have. It may not be the most current version.
It may not be.
You know, we can only work with what we can find.
I guess there's two ways of looking at it. You know, we can do a phenomenally exhaustive search for all these missing covenants, or we can just assume that they don't exist, write our zoning ordinances accordingly, and wait for the day when somebody comes in with a covenant in their hand that says that your zoning ordinance is in conflict with my covenant, and then we'll deal with it.
But is it even legal if it's not filed at the courthouse?
No.
So we wouldn't have to accept it.
But we don't know that it's not filed. We haven't been there to.
Well, in other words, if they came in and handed us one and it had a stamp on it certified by the courthouse, we would accept it.
Yeah, then we will still have to complete the process like Lynn said and make sure that that's the most recent copy.
Because your unit doesn't allow duplexes, but the copy I have doesn't say that. I don't have that revision that you're talking about.
Yeah.
What? Well, their duplexes all up and down Holiday Island Drive.
But they changed their unit to stop any future builds.
In 1985, they formed a committee and changed the covenants. No A-frames and no duplexes. So,
So what is,
I would take the latter approach. I wouldn't spend any more time looking for unit covenants.
Okay.
We've done the best we can to try to develop a zoning ordinance that's not in conflict with the unit covenants. But there's a limit to we're not responsible for the unit covenants.
But I heard him say he hasn't been to the courthouse
I haven't
to
been.
look for him.
I haven't
I
been.
think
to-
If somebody wants to volunteer to do that, Lynn will gladly provide them with a list of units that were missing. But in actuality, if you wanted to do the complete job, you'd have to look to make sure that what's on file at the county for every unit, all 50 some,
I would venture.
Correct.
that we have the latest covenant.
Because the ones that are posted online were just the ones that were in HICPC file drawer.
Mm-hmm.
And of all of those, I didn't find those in my online search. I found a different one.
Online search?
Yeah, I have a utility. I paid for a subscription to Data Scout to get into those kinds of details
Okay.
and put in a half a dozen different keywords looking for the covenants, for the reservations, all those. I only found one.
Yeah.
Didn't find any of those we already had.
Also obviously dependent upon what you typed in your search criteria.
Or the way they filed them
Or
and
the
named
way
them.
they filed them.
It's whatever the
Right.
courthouse did. So if I go to the courthouse and I say, I need the covenant for unit 1,
They're not
unit
gonna give you
18, there
better
you
off
go.
than you.
Where am I gonna find that? You gotta tell me what book and page it's on.
Yeah.
I have no clue.
You're probably right. It's almost,
File a FOIA request.
Make them find it?
Hell yes.
Oh God, we're already in pissant mode with those guys.
Yeah, that's right. What more can we do?
But that's the answer.
That's exactly the answer.
What is the
Do we know they're not in the file cabinets at the planning commission office?
Yes,
yes.
I have done that check.
Okay,
You
yeah.
have done
And Mickey asked Tom at the last planning commission meeting, you know, where are those covenants? And Tom said they're on, I think he said they're on file at the county.
His first response, I got them. Then he says, no, why don't they just go to the county and get them?
Yeah.
That was his second response. Make it easier, go to the county and get them.
They may or may not be there.
FOIA
I'm,
request.
you know,
Thank you for
I'm just
volunteering,
saying,
Mr. Pittman.
Sorry.
Thank you for volunteering for drafting that FOIA request. Here's the list.
I
Okay.
think we go back to Dan's suggestion.
I think we've,
Do that.
I think we've exhausted our search. We've done,
Due diligence.
yeah, we've done more, Lynn has done
Lynn, yes.
more than what we're required to do as far as due diligence on this whole thing.
All right.
We're gonna move forward with our ordinances, and if a problem comes up at some point in the future, we'll deal with it.
The one last thing I need to do is talk with the mayor of Town to find out what evidence or issues he has with this model. Because the Northwest Arkansas guy said the mayor knows it's got problems, so I need to find that too. I need to do that. And that was a question I asked
is
them.
rapidly growing into a medium-sized city, and
Yes, it is.
they're probably going through growing pains.
It's practically connected to Springdale right now.
What else could somebody do to help you out, then?
Drawing that map is a pain, but I know so little about doing it. I've forgotten how to do something that I need to figure out again. So drawing the map is huge, but it's software that it's on this laptop. You can't help with that. I don't know. I see it starting. I need to dig into
What
it.
is the map gonna look like?
It's going to be like our planning area map, and I can draw it in layers. I plan to draw a layer that says unit boundaries. So you turn it on, and all you see is the unit boundaries. And then I'm going to put, it says it's R1 in the covenants. I'm going to turn that whole area one color to match R1. And then I'm going to have a different layer because there might be some exceptions in that. So we're going to carve out the C's and the whatever in those sections. And I'll be able to look at the map and however you want to look at it. So if you want to see, I want to see all the units. I want to see just what's residential. I want to see what's just commercial. Different colors will pop up on how you reveal it.
I'm guessing GIS has maps that show lots.
I asked the Arkansas for that, and she, what she gave me was unusable.
Really?
I asked for a map from the Arkansas GIS of just the units, and they didn't have it.
Well, I can
They had it.
kind of understand maybe not having the units, because I don't know if those plat maps were drawn with GIS.
Probably not.
Probably a surveyor or somebody drew.
Yeah.
But it seems like you might be able to draw boundaries around sections of lots.
I can draw the unit numbers, and I can populate that and separate them, and you know. The software allows me to do that. That's how I did the street
I
map.
was just thinking maybe GIS could do this.
No, I asked and they didn't have any. They didn't help me with it.
The map, we can pass
the ordinance
the
without the
document
map?
without the map, right?
Not from what I read in the statute. It says it's a map and a text. To describe the zone areas, you have to have a map and a text. So when I say R1, R2, R3, C1, C2, I have to have a map associated with the text. It says and.
It doesn't say that they have to happen simultaneously.
Well,
Well,
maybe they're not valid until they both are there. I don't know.
And I think they would be considered valid.
I mean, someone could take a crayon and draw it out. That way, there's our map.
Then we
It's not very
photograph it.
precise, but it would be a map.
Well, we get Alex to do that.
Is it necessary to have a map? I mean, is
Is
that
it-
gonna provide value to us?
The
Well, he
statute
says
says
the
we're gonna have to
statute-
have a map and text.
The statute says that.
Draw it with a crayon
That's what I thought.
and take a picture,
And a kindergarten crayon, one that's got that great big, you know,
or use colored pencils.
yeah. I already did that in my pay stub. It's
Well, we
4
could,
sheets by whatever.
I mean, could you take
Not most
something
of it.
like that?
That's kind of what mine looks like.
Maybe we get one without that map without the color and start over on it. And
I've done that.
We just have a workshop,
I did that.
each one of us get a different color crayon.
Yeah.
Well, if you.
I can take it down to the print shop.
It doesn't say what the map needs to look like,
No, it doesn't. It says a map and text.
but if the text is,
The text would say Unit 1, and then this document's gonna say Unit 1, R1, blah, 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 except for lots 17, 18, 19, or C2. I mean, that, just like it's in the covenant, I gotta build a table that looks like that. That's the text.
well, then I think whatever map you've created would suffice.
And if you needed to handwrite some text on it, I know you probably print pretty good, so you can just handwrite that on there. And I went,
That's done.
what's the name, Rick's camera in Rogers, I believe, was where I got the plat maps photographed and digitalized that we put on the HICPC website. They told me they stand on a ladder with a camera.
I'm guessing that the color coding part of it is not a legal requirement. That's done as a visual aid because most cities have this huge area that's all zoned this, and then they have this huge area. They don't have like we have where Unit 5 has
Right.
these 3 blocks are this, and then these 2
But
blocks
that's-
are different. and
Exactly,
stuff like
that's what big cities have with square streets north
Right.
and south, but we don't have that. We've got R1 that also has C1 and 2 in it.
So if you, but the covenants, and therefore you either already have the table or a table could be made that says, that lists every unit, block, and lot in the table,
Yeah.
and it says what that unit, block, lot is zoned, and then your map is that map, which has all of the unit, blocks, and lots.
I like that. Why couldn't we do that? Yeah.
Okay.
Just a generic map with a table with specifics.
Right.
That'll be great. You can tell me what lots are in Unit 120 and 108 and 103.
They're all marked with unit, block, lot.
These aren't on those old maps. These Unit 200s aren't on those plot maps.
Oh, because they weren't
They
designated.
didn't exist then.
Those units weren't created.
Yeah.
Well,
And this 122 is somewhere between.
take the county map that they use underlying the county tax records.
Oh, theirs is easy. They just go school district 21H, boom, they're done. The rest is just all over the map for what they called it in their descriptions. That was the difficulty of finding what units do we have in the county records. They didn't
Could
name
you
them all the
could you
same.
get a map of each unit from them?
From the county?
Uh-huh.
I haven't asked them yet.
It would seem like that is something that somebody else could volunteer to do.
Because I know I can look them up online by unit,
If you spell it right.
if you spell it
Yeah,
right.
unit space 101, unit 101, unit hyphen 101.
Uh-huh.
If you spell it right.
Yeah.
That's how I found this
You
list.
just keep trying until you get the right
That's how I exhausted this
combination of
list.
characters.
Actually, if you type in the word unit, you get a pull down. You get to see all the ones they have that are spelled that way.
Yeah.
That's how I came up with this list. What do I need?
Because if you actually put that kind of detail on the map itself, we're gonna be printing those maps every time a lot gets changed. You know,
Changed
from
from-
C1 to C2,
That's true.
Or
We'd have to
R1
keep
to
it.
C1.
We'd have to keep it current.
and that's gonna be a nightmare. It'd be better not to have that on the map and keep it in a table that accompanies the map.
That's, yeah, much easier to maintain a spreadsheet.
The lot boundaries are gonna change much less frequently than the designations.
I think that, well, I don't know how we go about changing the designation of a lot.
Well, I mean, there will be a process, it may take a reassessment or
No,
whatever.
there's software you can use that we did that at the arsenal and
Well, I still think that the table of all lots in Holiday Island, what they're zoned, and, you know, and then a map that shows where all those lots are located is
units.
the answer to the problem.
I do too.
And the data has to exist because HICID assesses every
Yes,
unit,
exactly.
block, and lot in
Exactly.
Holiday Island. So the database has to exist.
Regina has
We
the
just
database
have to
on her PC.
Put it together in a format that we can
And
use.
we'll file a FOIA request with HICID then.
Yes, for
That'd be-
a table, unit, block, and lot,
Mhm.
all
Yep. In a sortable format.
Mhm. Well, you can always sort the columns.
As long as
So
it's in
then you can
spreadsheet.
sort all the
But
C1s,
you'll,
regardless of what unit they're in. You can sort all the R1s and R2s.
If you load that in
Present it in
Excel, you
different
can do
fashion.
that.
And if we ask for it in the wrong way, they can say, request denied because that table does not exist, I don't have to create it for you.
I said no, deny that.
I think
Okay,
HICID will give us whatever they have.
so someone volunteered to do that for us.
I thought Linda did.
Okay, all right. Unit, block, and lot, and their zoning.
What else? We're just
That's it
clicking
for
them
now.
right off.
Yeah,
I have seen the database.
Pretty soon
on the
you won't-
computer, so I
Pretty
know
soon you'll be
it's-
able to sleep at night.
but pretty soon my wife will quit complaining, right?
I think
So I
your idea,
I can't do
No,
anything
about
that.
this, the time I
This-
spend on this.
This committee has no control over that.
but I think your idea of a committee to kind of help you in this final push is a good idea.
You know, I'll spend some time on what I've got and then see how much having someone next to me.
Well,
would
can
help.
you just farm it out
Yeah, just-
individually and
Recommend to us
Okay.
what a committee or a single volunteer could do
I don't think you,
for you, and then, because right now, I don't know enough about it. I know that you and I are a lot alike. We put a lot of time into doing the research, and then we get to the point where we think, I can just do it myself easier than to explain to somebody how I got to this point. And, but
That's where I'm at.
whatever we can do,
Yeah, I'll be
We
glad
will
to help with whatever,
divvy it up.
if there's something
Well,
I can help with.
To his point earlier, whatever we do, if two or three, one or two of us pitch in to help him in the final push, it's gonna have to be a public meeting.
Yeah.
Well, it can be a workshop, I mean, still
But it's
public,
public, yeah.
It's still public.
but,
just
Yeah.
a work session, but he can
What we're
ask.
doing right here is workshops.
Exactly. Exactly.
But, I mean, you can,
I know I can't meet on the phone or meet someplace with someone
you
to work on
can
this together.
work up what we need, each one of us needs to do
Yeah.
and give it to us.
Or just work up a list of tasks and maybe we can figure out who can take them.
Yeah.
Okay.
And then we can work on those independently and then come back together.
All right, so on my to-do list, the missing DORs, the declarations from the courthouse, I don't need to do that. Okay. Update the comparative analysis, that's my spreadsheet.
now, as far as people working together on the same project or the same problem, we do have to be careful that we're not conducting a private meeting. However, I don't think that it's a problem to share files and stuff like that, like, if I'm gonna work on something with you, that, you send me the spreadsheet or something like that so I can work with it. I don't see where that's
I think so.
an issue. They're not really making.
I think the key might be, does it involve any decision making?
Right.
Right.
It doesn't,
No,
until you get back
Is
together.
it gonna make a difference in how someone votes on something?
Okay, that's all I have for today, Dan.
Okay, anything else then? Thanks. Next
Public
meeting,
comments?
next year?
There's only one member of the public left.
Okay,
They probably went to sleep.
Second
Yeah,
Tuesday,
they're taking their afternoon nap.
second Tuesday,
Next
January.
meeting is the second Tuesday. We wanna keep having them at 1 o'clock?
yeah.
I do.
Maybe should change the time.
I think that'd be a good idea.
we have to put that on as a resolution to change our meeting organization,
So we're talking January at this point.
January 11,
It's 11.
1/11/22.
Motion to adjourn.
So moved.
Second!
Ken seconded, all in favor, say aye.
Aye!
Opposed? We're adjourned.